Hey, this Ranga, it's okay. We can do. We can do. That's an interactive way. Jironi, okay, fine. Thank you, thank you. So we are talking about the development, the genesis of employment law. Okay? So we are saying that in 1964, a decision by the court in the case of Ridge versus Bedouin was to effect that the employer could hire and fire without giving an employee an opportunity to be heard. So I asked a question to say, was that fair? And all of you say, no, it wasn't fair. So, but the case, according to Lord Lade, his judge, this one decided to say, it is okay to hire and fire a person in that sense.
So it's more like putting business law from a based on
yeah, it's more or less than a business law, but this is more about employment, issues concerning employment. Okay? What are the laws that are governing employment issues? So we'll be looking at these employment issues. Similar to business law, but perhaps we'll go deeper than business law. Yeah, because business law, you are now focusing on business. Okay, because even in business, you follow laws and regulations. You have to pay taxes to the government. You have to do that and that and that and that. Okay, but employment is only now talking about the welfare of employees. Okay, we are now specifying. While business law is talking about business as an organization, while employment law is more of the employees only. Okay, yeah. So the decision came in because Lord Reid stipulated 3 classes of dismissal cases. Though this employee was not heard, wasn't brought for hearing, but the Lord Reid had to cite 3 areas whereby an employer can be able to sack out, an employer can be able to fire out without him being heard. Okay? So he cited 3 areas, 3 cases. Number 1 is that where there is a master and servant relationship, and where an employer could hire and fire. A master and servant relationship is not like an employee and employer relationship. Because a master is a master and a servant. A servant has got no powers. A servant has got no authorities. A servant has got no rights. Okay? So a master rules over a servant. And therefore, if a servant has done something wrong, a master has the powers to fire him out without hearing from this kind of servant. In this scenario, an employer is right to fire someone without being heard. Do we have servants in our homes here in Malawi? Do you have servants? Please, I'm not saying do you have workers, I'm asking whether you have servants.
No. No.
Anyway, so a servant is like a slave. In this case, a servant is a slave. So where you have a slave who is serving you, you at any point in time, whether ni usiku or ni masana or ntawiyanji Sunday or Mondays, you can fire this particular person without hearing from him. Okay? That is what Reid based his decision on this case of Rich versus Bedouin. That an employer could hire and fire without giving an employee an opportunity to be heard. So he was basing his sentence, he was basing his judgment based on the fact that there is a servant and master relationship. There is a slave and a master kind of relationship. So where there is this relationship, an employer has the right to fire someone without him being heard. Okay, that is the situation number one. The situation number two, where Lord Reid stipulated, is an issue whereby an office held at pleasure, for instance, that of a cabinet minister, where an employer could hire and fire as well. Have you ever heard that a minister has gone to court to sue for being fired out of the cabinet? Have you ever heard? No. Why? They have got one laws? No. Aha. It has pleased the president to appoint someone to be a minister. Okay? So that scenario of being pleased by someone, you can fire and hire without any notice or without him being heard. So if you become a president today, you can hire your friend to be a minister. Anytime. You can fire him, fire her also at any time. She will not go to court. No. Because it has pleased you to hire and it has also pleased you to fire. No question about it. Okay? But it is not the same in the employment contract. Because in the employment contract, as usual, you must sign the contract. And there, you cannot fire someone without him being heard. But in this scenario of a pleasure, someone is pleased to hire you or to fire you, then what does that be mlandu? What does that be mlandu? Okay? Another scenario where an employer can fire and hire anyone at any time. It is the dismissal from an office where there must be something against an employee to warrant his dismissal. For instance, contracts governed by statutes. If you have violated a constitution and you go into parliament and there's vote of no confidence, there and then, there's no hearing. You get the point? Like the president, if we want to fire the president, we simply go into parliament and lobby the parliamentarians and say, this president is not doing well, and therefore, we want to vote. So the majority of the parliamentarians, if they say, we don't want this president because of ABCD, it means that the president has been voted of having no confidence. There's no confidence about his work and so on and so forth. So, the dismissal can take place. This dismissal is a contract governed by statutes, whereby now the parliamentarians are involved of voting someone for having no confidence. So that kind of dismissal, no hearing. You don't need to hear their part. So you can see that there are these three areas where an employer can be able to dismiss someone without hearing him. What are they?
The question again.
Okay, I'm saying there are three scenarios where an employer can fire anyone at any time without hearing the part of the employee. without first hearing the part of the employee. In which scenarios are we talking about here?
Master and servant relationship.
Okay. Okay. An office where there's simply a pleasing office, whereby the employer is simply pleased to hire you. Okay. Yes. Another one. The last one.
Dismissal to my office.
Mm-hmm.
Where there must be something against an employee to warrant his dismissal.
Yes. And in this case, we're talking about contracts governed by statutes. If you are violated against the constitution, violated against the, any employment law, then there's no question. You're fired. You're fired. Like here, what guarantees an employee to be fired without being heard? Here at Unreal. Not coming for lectures. There's no question about it. If you don't come for lectures for 3 consecutive days, you're fired.
Yes.
You are dismissed completely. Okay. Okay. Yeah. So there are some other rules that would warrant a dismissal without being heard. So an organization would stipulate to say, if you do this and that and that and that, you are fired without any hearing. So when you go into organizations, please remember this, because you may see to it as Mina Sankwe Jitiga, but it's not true. Okay, let's.
The way the Anglican issue was fired. Yeah, the Abashwe guests.
Yeah. What was the case like? Can you remember? Yeah, but for what reasons? He slept with a girl.
No.
Uh-huh.
They said he do corruption.
Okay.
What?
Yeah. Yeah.
So they had to march.
Okay.
When the bishop is coming in,
yes,
the
congregation would march out.
Would march out.
Oh my goodness.
Leaving the bishop alone.
Oh, that was very bad. That was very bad. Yeah, but actually he was also granted a hearing. He was granted a hearing. There was a hearing that took place. He had to also say his part of why he's failing or why congregation are not liking him, something like that. So, yeah. But I know there are other cases whereby, like also a bishop was found with parts, human parts, in Mangochi. So that one was immediately a dismissal, no hearing about it, and he was jailed. He went to prison. He was found with human parts. Yeah, so that is a dismissal. That warrants a dismissal without hearing, without being heard. Okay, so the decision in Rage versus Bedouin left an employee unprotected. So you can see from the three scenarios, and in the case of Rage and Bedouin, it left an employee unprotected. In other words, now an employee is threatened at any time in point. He doesn't have that kind of energy to stand and face the employer. Why? Because the employer has the power to fire and hire anyone at any time. So in those days, the law was used in favor of the employer. So in those days, the employer was having all the powers, and an employee, because he is mannerless, he's mannerless, he has no powers, he can't go anywhere. Yeah, so the law was in favor of the employer. So through this decision, the employer could, for instance, dismiss an employee without following principles of natural justice. What is natural justice? What is a natural justice? A natural justice is simply umuntu, because as a human being, you have the right. You have the right to be heard. You have the right to express yourself. You have the right to let other people also hear your side. It's not just, you remember in the Bible, there was a woman who was caught doing adultery. And the people brought her in front of Jesus. And then they said, Master, we have found her committing adultery. And our law says we must stone her to death. So now the question was, where is the man? Yes. Where is the man? Where is the man? You have just brought a woman here. Where is the man? So Jesus said, Ngari wina alipa minesana chimwepo. Ayambe kumponya mnyala. So in other words, Jesus was trying to give her an opportunity to be heard. So no where is the man? Tell us, and so on and so forth. Yeah, but what I'm saying is that in those days, the employer could dismiss anyone else without following the principles of natural justice. So the court treated the contract as validly terminated, and the employee's remedy constituted damages only. In other words, in those days, an employee would just get a peanut just because he's been fired. Adangompa 1 month notice, full stop. As given 1 month notice, I will be which is very bad. Yeah, so that's what Lord Reid judged his case. So, after that, what happened? The state was partially rectified by the 1994 Constitution. The state of firing and hiring without using the principles of natural justice. What are the principles of natural justice? Come again? An employee must be heard first before being fired. So that state of an employer having all the powers to fire and hire anyone else at any time has been rectified in the 1994 Constitution. Were you there by then?
No.
You were not there?
19 what?
1994. You guys, eh?
You mean you're 30 years old?
Yeah, I mean, you're not 30 years old.
Oh my goodness.
You guys, you're very small, eh?
Very.
You're babies, yes. Ndekutima tubyanu mukumaja uje ni kwambiri nyama sasa. I thought you were above 30 already. That's what I thought. But then I'm joking. Yeah, but 1994 is not far away from today, okay? Just 30 years ago. And I'm surprised to say 30 years ago. 1994, 30 years ago.
That's 30 years ago.
Yeah. Exactly 30 years ago, you're right. Yeah, but anyway, the Constitution was rectified in 1994. So, in fact, the High Court began to make purposive interpretation of Section 31 of the Constitution. So the High Court now sat down and said, gentlemen, I think we are not doing natural justice here. How can we invest all the powers in the employer and give nothing to an employee? No, let's do something. Let's do something. So the Constitution was changed, 1994. Remember that the first Constitution was under one-party system, huh?
Sir,
Yes.
can I ask a question?
Yes.
these laws,
Yes.
are they applied for the whole world, or Malawi has its own laws? Another country has its own laws for employees to follow, or these are made for all employees around the world?
Exactly. That's a very good question. What do you think?
So Malawi law. Yes, answer. International.
Our focus will be much on the Malawian employment law. Okay? But there's an international law for, yes. But however, much as we will focus on Malawi law, but this Malawi law is being borrowed from also other sources like ILO. Have you ever heard about ILO? 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 International Labor, okay? International Labor Organization. This is an international one, where some of the laws that we are applying here in Malawi are coming from the conventions of ILO, International Labor Laws. We will see the sources of our laws here. Yeah.
I just know some of the laws that are adopted from women at the Bonga, Malawi, or Britain.
British.
Because like the English ecosystem adopted.
Exactly. Because before independence, we had the laws from Britain, and the British law was indeed taking place here. But after independence, we only added a few things. Okay, still we were under the British government in the sense that we are a Commonwealth country. Because we are a Commonwealth country, we still abide by chief Nanu king then panopa queen anamwalira uche queen anamwalira but ali pano ndani kaya Queen Elizabeth mwana wake is it Charles?
Charles.
Okay, so we're still using such old laws. So Kam was only added a few things, but Bagiri Moose, when he came in 1994, there was also a change. Okay, there was also a change, and this change came in, and therefore section number 31 of the Constitution was amended, was interpreted in a way which is good. Section 31 down there, if you look at that one, section 31 says, every person shall have the right to fair and safe labor practices and fair remuneration. So this statement alone is talking a lot of things. And so judges in the High Court began now to interpret it in a way that is also good for employees. Remember, we're talking about the development of employment law, okay? I know you are tired already. When Insima is boiling, you feel dizzy and you like to go to sleep. But I'm sure you'll be awake. Good. So, the further development of employee law took place through the adoption of LRA. What does that mean? Hey, my goodness. LRA. LRA.
The R, Republic. The A,
All right, that's good. The L stands for labor, and the R stands for relationship, and the A stands for act. Okay? Relations Act. Yes. So, the adoption of Labor Relations Act in 1996 is providing what we call collective bargaining, and is specialized, and a specialized court was also put in place to determine labor-related disputes. What kind of court? What's the name of the court? That is specifically put in place to determine labor relations issues. Supreme is an overall, is a mother body. What? Industrial court. Okay? Industrial court. So the industrial. Come again? The question was to say, which court are we talking about here, a specialized court, to determine a labor-related dispute? The name of the court is industrial court. IR, industrial court. IR, industrial court. So the coming in of Labor Relations Act 1996 provided a collective bargaining. In other words, sit down with your employee and start discussing. So it may not be maybe directly with your employee, but you can use a union. Like here at UNRIL, you are a president, I understand. For the students, it is a union, isn't it? It is a union. And where there are grievances, where there are challenges, it is you and your team going to the management and say, please, please, okay? It's like you're pleading. Now, that kind of pleading, you're not pleading on your own behalf, but you're pleading on behalf of the students. So the fact that you're pleading on behalf of the students, that is what we call a collective bargaining. Is it on Vega? That is a collective bargaining. So the Labor Relations Act provided such kind of an avenue, provided such a room where collective bargaining can take place. And not only that, instituted a court known as industrial court, whereby issues concerning labor, they can be considered, and they can be people can be helped there. Again, remember, we're still talking about the development of employment law, how it came into being. Again, in the enactment of the Employment Act in the year 2000 has helped to address vulnerable position of an individual employee and consolidated several statutes touching on employment. So the coming in of the Employment Act in the year 2000, it has also helped to make sure that an individual employee is not vulnerable. It's not vulnerable. It's been covered. It's been covered. So today, you human resource managers, don't dare to fire anyone else unprocedurally. Okay? Don't dare to fire anyone else unprocedurally. Yes.
What if they steal?
Aha. What if they steal? What is going to be the procedure for you to fire this one, even though he has stolen something? What will be the procedure?
Fire them.
Simply to fire them. Someone has stolen something. Do you simply say, go away because you have stolen a computer? You have stolen a camera?
There are many ways of punishing.
Okay.
For letting them know that what they've done is wrong.
Mm-hmm.
Some can be put on leave, be paid salary or whatever.
Okay.
Some can be demoted. They were a manager of a position here, right? Others are saying we will be replaced with life. Yeah.
Okay. But as you're coming to that particular decision, what do you need to do first before coming up with that decision?
Maybe a person go to court. For example, there's still millions in the company.
So what do you do? What are the procedures? Before firing, before coming up with that decision, before coming up with that decision of firing him or her, what are the steps that must be taken?
You need them to give us back our money.
That is the final decision that you're making.
So that when we are married, me or person, I can't bring them up. Why don't you even have the problem? For example, about 50 million. Imagine, great.
Abwezi.
Then we just say for me, you mean you are you are waiting for a okay. I think the first thing to do is to find proof if they have really stolen the money.
Okay. How do you do that?
Investigate.
Aha. Yes, good.
The more you make them stay to investigate, the more they still go back. You just can't fire a person. This is another but it's 3 months notice.
No, but before you come to that decision, there must be steps that you are taking.
Question them.
You
question them first.
Okay.
They don't give you what you want to hear. Send them to the police.
Okay. That is questioning. Questioning is about what?
About the
when you're questioning, what is it that you want to establish? You want to establish what?
To get answers.
You want to get answers. Okay. Yeah. Okay. So what we are saying here is that procedurally we mean that you must go step by step before you come up with your decision as a manager. So the first thing is to investigate, as you have said. Do the investigation. And after establishing the bottom part of it, then you call him or her for hearing. And let him or her express himself or herself. And after that, you allow him or her to write a report on what he has said. Because if it is simply verbal, one day so you ask him or her to write a report based on what he has said. And after that, then you can make a decision. You can make a decision. So what we're saying here is that a procedure must be followed. And these procedures are stipulated in the policies of an organization. But if you don't look into the policies in your organization, and yet something has been happening, and an employee has wronged the company, and you simply come to a judgment without hearing, without following the procedures, when he goes to court, the court will look at your policy, and you'll look at all your procedures. If you skip one of those off, today, Brian Banda is gone away with my money. Millions and millions of kwachas. Why is he pocketing millions and millions of kwachas today from our taxes? Why? It's because, yes, it's because he was dismissed, okay, and procedurally. In other words, he was dismissed without following the procedures. Brian Banda, don't you know? Brian Banda was working at the State House. Aye. At a win and how he was campaigning for MCP. At first he was good times. Wanted to say thank you to these two guys. Brian Banda and Mzake Uja. Alikuwa MBC Uja. So anamtenga Uja kumwisa kwa MBC, anamtenga Brian Banda ndo kumwisa ku State House. Ngati chan officer, communication officer kajani. Okay? But before even 2 years, Brian Banda was sacked, was fired. Now the president forgot that there are 3 scenarios where one can be fired without being heard. What are the 3 scenarios? Relationship? Yes. The pleasing part? where it has pleased the Bwana to hire you. And the last one, a dismissal office where someone would be dismissed based on what he has done, but it has to be a contract governed by statutes. Okay, now this Brian Banda was, for example, he signed a contract. He entered into an employment contract, okay, whereby he signed a contract, he signed everything, as a full-time employee in the government, State House. So here he was fired by the president. I don't know who was there, but he was fired. But that was unprocedural. The president did not follow the procedures. And Brian Banda went into court and sued that I have been sacked without being heard. And the court said, give him his dues. And the guy pocketed lots and lots of monies. He's a happy person today. He's a happy person today. Okay? Why? Because the employer did not follow the procedures. So the enactment of the Employment Act in the year 2000 has helped to address this kind of vulnerability. But before that, that sucking out of Brian Banda would have been forever, for good, and no one else would question. But because now there are courts, there are these employment acts, there are these other laws, now things are better for the employees. So please follow the procedures before you sack out anyone else.
So someone can be sacked from the State House and still work cleaner?
Yes, I have someone I know. He was sacked to Capitol Hill by the PS.
So wait, I'm
Yes, not to Bujo Samboma, but transferring you from one department to another department. You were talking about taking away someone from the government into a private, like Brian. No, that Brian completely was sacked, and therefore he's not part of government. He's not part of government.
That's possible.
It's possible, yes. Then you have to pay heavy money to this employee. Yes, yes, yes. But the one that I'm talking about, the PS, was sacked, was fired out. So he was fired out, and then he has been given another job. Yes, in the same government. But he's paid all his dues as a PS. They have just simply removed him physically. But all the payments, salaries, benefits, he still be paid as a PS. You can imagine this world. Okay, so as we have looked at section 31 of the Constitution, it is clearly introducing the concept of natural justice into what has traditionally been a private law domain. So section 31 of the Constitution is clearly talking about the natural justice. Natural justice is what? What is natural justice? Natural intelligence, okay? Yes, let people be heard. That's part of natural justice. Yes. So it is no longer a private law domain. And an example has been given here. IRC. What's the name? What does it mean? IRC? 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 Mm-hmm.
I don't know the arts.
Okay, it is Industrial Relations Court. Yeah, please take note of that. IRC is Industrial Relations Court. So the Industrial Relations Court in Australia, in a case Nexum versus Heaven and Earth Galley Private Limited, states that the relevant principle is that a person should not exercise legal power over another. Okay? A person should not exercise legal powers over another to that of other person's disadvantage. Because if I'm using my money, to fire someone else because I have got money, that is wrong. So to that of other person's disadvantage, and for a reason personal to him or her, without first affording the affected person an opportunity to present his case. Pamene babapo mutapita ku court, mutasentima chotani. Oh, I'm in front of the camera, sorry. You know, when you go to court, they will not look at the degree of the case, whether he's stolen billions of kwachas, whether he has done something very, very, very grave, something that is very, 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 you know, a person with a spirit cannot do it. They will not look into that. They will look into the procedures. What have you done? Have you given him or her chance to express herself or himself or not? So these are the things that the court, according the court in Australia, according to Nixon and Nixon versus Heaven and the Earth Galley Private Limited, stated that indeed a person must be afforded an opportunity to present his case. To present his case. Good. Soon you become HRs, eh? Very soon. Soon and very soon. So, have you heard what it means to fire a person? A natural justice must be.
But a good HR must fire.
Yes. Yes.
Yeah, they become comfortable. So we need to fire them.
You fire them just because they have been staying comfortably in the company.
What if they're doing?
Okay. No, muzaziona when you get there. Okay, good. Right, so that is the genesis, okay? We were talking about the genesis, the development of employment law. Okay? Mwamvesa background yake, where we're coming from. It should be very clear for you, otherwise you may say, you know, this employment law, where is it coming from? Good. Let's start with the definition of an employee. Who is an employee? Who is an employee in your own words?
Person who offers services under an overall or written contract of employment.
Is reading you there?
No.
You're not reading. Okay. You can read from the board.
Okay. An employee. Somebody.
Yes.
Is a person
Yes.
who does a service for an organization.
Okay.
For money.
Okay. For money. Okay. All right. Okay.
For experience.
How would you differentiate between a worker, an employee, and the...
You know what?
What are you laughing?
I was like a servant. I'm laughing because I was like, maybe a servant.
Oh, okay. No, I'm asking about an employee, a worker, and a self-employed person.
A self-employed is a person employed by themselves. Like, for example, I'm doing my own business.
Yes.
Self-employed.
Yes.
An employee is somebody who is hired by an employer. Yes, to do a certain job.
Okay.
A worker is the difference between an employee and a worker. It's somebody who's doing the job.
Okay. Anyone else would differentiate between the two or
I
three?
think it's not that different because they both work under a contract. It's just a pretty an employee and a worker. The only difference is that this is my employees and my benefits and within the way. In the law, within our employees.
Okay. Okay. Yes, exactly. So a worker is simply someone who is working on a contract, but not a written contract.
What? An employee?
A worker is working on a contract, but not a written contract. Suppose these guys that you see along the road, they dig. They're digging. Who are they? Are they employees or workers? They are workers. They are simply given a piece of work. Okay, brother, work 10 meters and I'll give you 5,000. That's all. They are working on agreement, but not a written agreement, not a written a contract. While an employee is someone who is working, but on a written contract. Okay? On a written contract. It might be a 6 months contract, 1 year contract, 2 years, 3 years, 5 years contract. It is written. It is written. While a self-employed, as you have put it, is someone who has employed himself. There's no any written document about him. But if he himself wants to do a service to someone else, this is where now a contract comes in. You have to sign a contract between the two parties. It's like you are running a stationery shop and you want to be supplying stationery to Unreal. So what you do is you sign a contract between you and Unreal so that you are able to supply stationery materials. So that's the difference between these three. But here we want to understand who is an employee. According to EA, what does EA mean? Aha, very good. Well done. Well done. Well done. A big hand for her. Employment Act. And LRA stands for? Labor Relations Act. Labor Relations Act. So according to Employment Act and Labor Relations Act, an employee is a person who offers his services under a contract of employment. Under a contract of employment. Or any person who performs work or services for another person for remuneration or reward on such terms and conditions that he or she is in relationship to that person in a position of economic independence and under the obligation to perform duties for the person more closely resembling the relationship of employee than of an independent contractor. In simple terms, we're saying an employee is a person who is engaged in an employment contract for money. For money. So, that kind of contract, it might be a work or a service. What is a service like? It might be a work or a service. It might be a work or a service.
It's just for children at the time.
Service.
Example, let's say. Yes. Teaching is a service. Yes, exactly. Exactly. What else? Kuchipata tikapita kucha. The restaurants. They are there to serve people. Okay? While work is ijatima kesatukudaiji. And so on and so forth. It's work. Okay. So, that kind of contract might be a work or a service. A service. So as long as there is an agreement between the two of you, and at the end of the day, money is given out. So that is an employee. That is an employee. Okay? That is an employee. So, through this definition, we can see that the definition is making no distinction between a permanent employee and one on probation or a casual worker or a seasonal worker. Okay? So an employee is either someone on full-time, which is permanent. An employee is someone who is on probation. An employee is someone who is on casual. An employee is someone who is also on season. What's the difference between casual and season? What's the difference between casual work and season work?
Casual work is the normal, like what you do is casual work. While seasonal, like farmers. I mean, it's seasonal.
Yeah, exactly. So casual work is ganyo. Bagwira maganyo basi. Bagwira ganyo chakudia yatu cha lero chatani chapezeka. That's casual. While seasonal, you go by the season per year. For example, tobacco industry. Tobacco industry, they employ people around April up to October. Is it? Up to October or September? So in between. So it's seasonal. When you go to Skoma, Ilovo, they also employ people on season. So that also helps people to know that indeed he is a seasonal worker. Okay, good. So an example has been given here in the tobacco industry. In the case of Gamma versus others, Gamma and others versus Diamond Malawi Limited. The court took judicial notice of the fact that the tobacco industry uses seasonal labor, and it observed that seasonal employment belongs to the category of contracts for a specific task. So you are not simply there just to hire and fire the seasonal ones. There is a specific contract, and this contract is on a specific task, and therefore a procedure also must be followed. In section 43 of the Employment Act, it is provided that where an employee is engaged in an undertaking in which it is customary to employ some employees only at certain seasons of the year, and an employee is employed for successful seasons, the employee shall be deemed to have been continuously employed for the aggregate of all the time he has actually performed work for the same employer for continuous seasons. Have you understood that statement? Okay. In short terms, we say, if you are employing people on season or seasonally, this year you have employed the same person, next year the same person, the other year the same person, the court will say, much as this one was being hired through seasons, but he is a continuous worker, and therefore he must be given all his dues. That is why ifeyo ametuma bwera aganyo fe kunoko. We sign a contract per semester. So after a semester, that contract is finished. And we have to sign another contract for the other semester. And so on and so forth. The reason behind is that we cannot go to court and say, I have been a continuous worker. No. They say, no, you worked here, this is where you stopped. Finish. Had it been that there was no contract of signing contract, then I would claim to say, I have been a continuous worker, and therefore I need my money from year number so-so to this particular date. So here, the section 43 of the Employment Act is providing that kind of avenue, where the act is trying to say, if you have employed a person on season, using seasonal kind of employment contract, if he's continuously doing that every year, that one is doomed to be an employee all the time. So you are definitely, guys, as HRs, because otherwise, if you don't follow this is a kuvutana. Okay? Ndalama za company zambiri zizapita because of you. Ndezi kapita ndalama zambiri za company, you'll be fired. All right. In summary, a worker is the one who has a contract employment and is called an employee. The contract in this case, we mean the relationship which is there between the employer and the employee. And sometimes it is referred to as a contract of a master and servant. A master and servant. And this is a contract of service and not a contract for service in which self-employed person works. So we are only talking about this relationship between an employee and an employer, whereby a contract is being offered. A contract is being offered. Good. Who is an employer? Who is an employer? Any idea? Yes, madam?
Employer can be a person who offers services to their employees.
Okay, a person who offers services to the employees. Okay, good. What else, madam? Can you try, President? Who is an employer in your own words? Okay, so according to EA means Employment Act. Employment Act. And LRA? Labor Relations Act. An employer is any person. Okay? You and me can be an employer. Or a body, corporate, a group of people undertaking or public authority. Public authority, in this case, we're talking about a government. Or board of persons. Board of persons would be Antawida, Tato, and I. Who or which employs an employee and includes the heirs. When you talk about heirs, we're talking about if your dad dies, you take over the company. Okay? You take over the company, so you're an heir. So at the moment you're taking over the company, you're also taking over the responsibilities to pay the employees that are under, that were under your dad. Okay? And successors. Successors are the people that are,
when, for example, my dad.
Yes.
has reached his retirement
Yes.
age, and he gives it to the first one, maybe my brother, or my brother or sister.
Yes.
That means he has succeeded.
Yes.
It's a success.
It's a success. Exactly. Like in Pinganjira, resigned from running FDH. Manawake. Yes. So that is a successor. And the assignees. Who are these assignees of the employer? Assignees are the people that are also signatories or maybe shareholders. Okay? Yeah, shareholders. Or where appropriate, a former employer, someone is, this is now about taking over. Okay? You were an employer in this company and someone has taken over. So the former employer was able to pay this one. The new employer must also pay. If, for example, the former employer managed to keep pension money for the employees, the one who has taken over, okay, must also recognize that these employees have got pension money in the account, something like that. So all these that we're talking about here are the employers. And you cannot run away and say, inaenda kukupezani, sini kukuziwani, kumeni mwachokera. You are not a good employer. So whether you have taken over, whether you have succeeded someone else, whether you have bought a company, whether you are a signee, whether you are an heir, you are an employer. So the definition is more encompassing in order to protect employees in situations such as death, acquisition, sold of a company, or transfer of undertaking. Okay? So it is trying to protect employees in situations of death. Suppose your dad has died. Would the children say, no, you are not an employee here? No. The children will take responsibility of giving this employee his dues. Suppose the company has been sold, another company has acquired. Would this company say, because I wasn't there when you were employed, so you are not an employee? No way. Okay? Or the company has made some transfers, another company has joined you, has come in, and therefore all this is to protect employees so that they still feel that whoever has taken over is an employer. Good. Definition of employment. What is employment? Employment is a relationship between two parties regulating the provision of paid labor services, usually based on a contract. One party is the employer and the other party is an employee. So that relationship between two parties is what we call employment. And this relationship is always on a contract basis. You sign a contract, you agree. Okay? Good. So we have looked at the genesis, the development of employment law, and we have looked at the definitions of who is an employee, who is an employer, and what is employment. I'm sure if I give you a question on these 3 areas or 2 areas, you'll be able to answer. Ready? Good. Let's come to the sources of labor laws or employment laws. Sources of labor laws. Where do we get all these laws that we're talking about here? Remember, the law is that an employer must follow natural justice. And what is natural justice?
Great.
Yes. Give chance to the employee before you fire him or her, so that he is also able to express his or her side. So let's look at the sources of labor laws. The sources of labor laws are as follows. Number 1, the Constitution of Malawi. So you cannot talk about labor laws minus the Constitution of Malawi. Why Constitution of Malawi? Why Constitution of Malawi? Why Constitution of Malawi? Is what?
Because it's the head and it's where the employment
Yeah, you're trying. Yes. You're trying. Anyone to finish? Yes. Okay. Good. So it is a supreme law. In other words, it is the law which is above all laws. So all other laws that are listed here down, they are all how to pronounce this? They are taken away from this supreme law. Yes, extracted from this law. So the laws that you see here, they have been taken from this one. It is the supreme law. It is the above all laws. And that's why even the president says no one is above law. He's trying to mean this one, the constitution. And when he is vowing for his position, he vows that he will never dilute or deliberately neglect the Constitution of Malawi. And he says, I will defend the Constitution of Malawi. It is the law. It is the supreme law. So, our sources of labor laws are coming, first of all, from the Constitution of Malawi. Have we got that booklet, the Constitution of Malawi, yourselves? Do you have the Constitution of Malawi? You guys?
I have the one.
You have a soft copy or hard copy? Oh, okay. What about you other guys? Do you have a soft copy or hard copy? Okay, please make sure that you have a constitution with you, either soft or hard copy. Very important. Very important. Very important. Because we will be citing some cases or some other chapters or articles from the Constitution of Malawi. Another source of labor laws is the Employment Act. The Employment Act is one of the sources of labor laws. This is where we will find many laws concerning labor, concerning employment. It is in the Employment Act. When was it enacted?
1994, 2000. Which one?
Employment Act. When was it enacted? Okay. Room number 6?
Yes.
Mwasiwera goma bwana. Okay. Ndemo mwajira dala. Yeah, I think from the okay, good. The Employment Act is one of the sources of labor laws, and then the Labor Relations Act. Labor Relations Act. This is also where we can find labor laws. Labor laws. The Pension Act. We have a Pension Act where you as organizations, you must remit pension money through, who are the companies that are handling or managing pension money? Companies. Yes. Yeah, Nico. What else? Old Mutual. Yes, Old Mutual. So these are companies that always manage pension money. Okay, we have another source is Workers' Compensation Act. Workers' Compensation Act. So the Workers' Compensation Act is also one of the sources of labor laws. Labor laws. We'll talk more about the Workers' Compensation Act. Occupation, Safety, Health, and Welfare Act is also a source of labor laws. When we talk about safety and health is what? We talk about health and safety. Safety and health is concerning what? It's concerning the health of a person. Technical Entrepreneur and Vocational Education Training Act. This is TVETA Act. TVETA Act is also one of the sources of labor laws, because in the TVETA Act, there are some rules and regulations governing employment, that are governing employment. Companies Act. This is where now company law is coming in. Okay? They are getting it from Company Act. Companies Act. Public Service Act. This is also another place where labor can also be found. Labor laws can also be found. International Labor Organization Convention, ILO. Remember I talked about ILO? In the first place when we were introducing it? International Labor Organizations Convention, that's ILOC. ILOC is an international labor law where Malawi also is part of it. Malawi is also part of it. Good. Tiambebo? Tiambe kuzisukuta chimosi. Okay. We need to start afresh. All right. Thank you so much for being together. Being the first day, I can understand that we have already consumed a lot. And therefore, when we meet, we will start explaining and looking at each of these sources of labor laws. Thank you so much.